Bert Newborn is, I think, like Deborah Hensler, one of those people who really doesn't need an introduction, or very much of one. But he is a former national legal director of the ACLU. He is the Inez Milholland Professor of Civil Liberties at NYU, and is currently, thankfully, visiting at Stanford for the next 2 quarters and teaching a course on the First Amendment next quarter that I hope to take. So he was the lead counsel in the Holocaust litigation against Swiss banks and won a $1.25 billion settlement, and has some slight, or maybe more than slight, as he'll tell you, experience in this case as well. He filed an amicus brief in the Second Circuit, as I understand. So he will introduce the panelists, and I hope you enjoy.
Thanks. Thanks, Matt. And thank you all for coming, and thank many of you for staying for the second panel. I thought the first 3 speakers were terrific, and I learned a great deal. And particularly want to thank the students for setting this up, and for the journal. I think they've chosen a terrific topic. As Matt mentioned, I'm visiting at Stanford this year, having spent the last 41 years teaching at NYU. And I sometimes think that I'm Woody Allen. I'm here in paradise, but I'm finding it very difficult to be happy without a little edginess. So if any of you could go out and sort of scratch my car or something like that, I'd feel much better. Let me introduce the panel. It's a wonderful panel. To my right is Maya Steinitz. Maya is a professor of law at Iowa College of Law. She teaches civil procedure, transnational litigation, international arbitration, and international business transactions. She has an LLB from Hebrew University, an LLM from NYU, and a JSD from NYU, and I remember her very fondly from NYU. She's done something quite extraordinary for an academic. She's identified a problem in 2 very good law review articles in William and Mary and Minnesota. But then she's gone on the line and actually tried to help solve it. Because this panel is all about the benefits and pitfalls of third-party funding of this kind of litigation. Where the money come from to get this litigation started in the first place, if it came from venture capitalists, what are the particular problems that we have with that, what are the particular opportunities with that. And Maya has actually drafted a model litigation finance contract that should govern the relationships. I mean, she's actually gone down to the rubber on the road and drafted such a contract, put it out on the web, and runs an excellent blog where lawyers can discuss problems like this as we attempt to evolve towards some sort of mechanism for coping with recognizing that all of a sudden venture capitalists are funding some of this litigation. And to my left is a dear friend and an old colleague, Marty Redish, who is the Lewis and Harriet Ancel Professor of Public Policy at Northwestern Law School, and who teaches constitutional law and free speech, and who has written a wonderful book called Wholesale Justice, which is a critique of the class action system and recognition of its strengths and its weaknesses. And 2 earlier books that I learned a great deal from, Money Talks, which is a wonderful book about campaign financing, and a constitutional political structure, which is an overview of the theory of the Constitution that Oxford Press published back in 1995. And Marty and I are squaring off in the Texas Law Review later this year in a debate about whether free speech perhaps has turned the corner and gone a little too far. So I think each panelist will take 20 minutes to lay out their particular position. I think it probably makes sense to ask Marty to go first, because Marty has a general overview of the area, and then Maya will explain to you what the litigation contract ought to look like. And then I'll pipe in a little bit at the end, and we'll go to the audience.
Thanks, Bert. Well, I will be the first speaker to go beyond the specific context of this case and take one of the issues that's raised in this case and look at it on a broader level. The issue of third-party financing. But let me give you a little background. As Bert said, in 2009, I wrote the book Wholesale Justice. Coincidentally, it was published by Stanford University Press. And it was basically designed to raise questions about the constitutionality of many aspects of the modern class action. And it caused quite a stir on the blogs. I was either Darth Vader or a folk hero, depending on the ideological predisposition of the blog writer. And I thought that was unfortunate because I didn't see what I was doing as something about ideology. I saw it as something about process. And ultimately, if you don't maintain the process, you really have nothing. And all my writing in procedure has focused on that. When I started looking into the third-party financing issue, something I hadn't really focused on before I was asked to do this paper, I realized that there are implications for the analysis of third-party financing for the modern class action. And that's why I entitled my talk, Viewing the Modern Class Action Through the Lens of Third-Party Financing. Let's talk first about the issues of third-party financing. John Beisner, well-known class action lawyer, defense lawyer in Washington, for whom I have the greatest respect, wrote a white paper for the National Chamber of Commerce challenging the legitimacy and the propriety of third-party financing. And as I said, I have great respect for John, and it was being written by a major defense lawyer for the National Chamber of Commerce. It was a dead giveaway that this was not going to be an objective analysis and didn't purport to be. It was the defense bar's perspective on the issue. And from that piece and other works on third-party funding, I saw there were basically three major concerns that the opponents were raising. And while I do see some serious questions about third-party funding in general, I didn't find any of the three concerns on which the attacks relied to be dispositive or deal-breaking. To the extent they were problems that could likely be dealt with without abandoning the idea of third-party financing. The primary argument used, as I've seen it, against third-party financing was that we are simply going to be increasing frivolous litigation. That frivolous litigation that can't be brought now because of a lack of adequate funding will be able to be brought as a result of third-party funding. And I suppose that's theoretically possible, but it's equally possible that legitimate, worthy litigation will now be brought, which couldn't have been brought otherwise because of third-party funding. And ex ante, there's no way to know which it's going to be. More importantly, to the extent frivolous litigation does increase or does present a special problem, I think we need to use a scalpel rather than a hatchet. We already have in our system ways to deal with frivolous litigation. We have Rule 11. We have the Twombly expansion or modification of pleading requirements. And those are devices more directly aimed, zeroing in on the issue of frivolous litigation. The third-party funding issue goes more to the hatchet. You get rid of third-party funding, you might be throwing out good litigation as well as bad. The second was the violations of ethical prohibitions that might result, particularly attorney-client privilege. Well, actually, the ethical prohibitions are champerty, barratry, and maintenance. So when I was in law school, we learned about the evils of maintaining litigation, about lawyers funding litigation or making sure that the client's costs were taken care of. I think the ship has sailed on those violations. One could debate how legitimate those were. Well, did they have legitimate motivation when they developed in the 1800s? In modern times, we've understood that those ethical prohibitions are not the problem we thought they were, or the benefits outweigh the harms caused by it. The modern class action system is basically an attorney funding mechanism, why should funding by third parties be any worse from the ethical perspective? And finally, as I have up there, the supposed threat to the attorney-client privilege, that the attorney will be revealing to the third-party funders things learned from a connection with the client, and that would violate the privilege. And the response, I think, is don't do that. There's nothing inherent in the concept of third-party funding that would authorize those violations. It's true, it creates an environment where that might be more possible than if that environment didn't exist, but it's a problem that can probably be dealt with without getting rid of third-party funding. I don't consider it to be the deal breaker. So I didn't find any of the arguments that John Beisner or other opponents have made to be all that persuasive. But as I thought about the issue of third-party funding, there was something that made me uneasy about it. Well, in case I should remember how I organized. The benefits of third-party funding are what I call capitalistic socialism. This oxymoron that we can increase distribution of resources as a result of capitalistic profit-making motivations. You can do well by doing good. And if there are redistributions that the law dictates, then the capitalistic profit-making motivations can help achieve that. So there are clear benefits from third-party financing. But now to what I consider the real risk. And it's more of an unease on my part. What you've done with third-party funding is you've created a financially interested group of third parties who lack a real relationship with the clients. Will that cause a problem? Will the client's interests be ignored or undermined? You do have the attorney in between the third party and the clients, and presumably the attorney has a relationship with the clients and can filter out any perverse incentives that might arise where the financial interests of the third parties might conflict in some way with those of the client. Is this a reason to get rid of third-party financing, to prevent it? No, I don't think it is. But it's not a non-existent problem. And as I thought about the criticisms I had made of the class action in my book in 2009, by considering the problem that I saw in third-party funding, it occurred to me I can now see a different rationale for the concerns I had when I wrote my book. And that is that the modern class action creates many of the same problems that I see in third-party funding. The modern class action does not follow the traditional attorney-client relationship. Even the contingent fee situation in the individualized litigation, the attorney knows the client. The attorney has a relationship with the client. In the modern class action, it's a very different situation. Think about the ways in which the class action differs from the traditional attorney-client relationship. The modern class action, there's no doubt that in the overwhelming number of damage class actions, the attorneys are the driving force. And there's nothing unethical or improper about that under the modern view of ethical rule. But it's clearly the case that the attorneys are the ones who are starting the process. I remember when I was involved in asbestos litigation down in Texas, the plaintiffs' lawyers would bring an X-ray machine to the union halls and check out different workers to see if they had injuries. Again, I'm not suggesting that's illegal or immoral or unethical, but it's clear that the attorneys were the driving force. That's not the traditional situation. The traditional situation is the attorney has an injury and he or she seeks out an attorney. Okay. Secondly, unlike the traditional process, where we can have some protections of the clients from the one-on-one relationship the attorney has with the client, the class attorneys in most of these cases are much more in the position of the third-party funder than they are in the position of the traditional one-on-one attorney relationship. If they have contact with the clients, it is only the named parties. There is a mass of clients out there with whom they have no connection. And if you think about it, that might explain the potential conflict of interest with class members. Think how many class attorneys fight to have their classes categorized as B2 rather than B3. Think of the Walmart litigation. It didn't work, but that was clearly what they were trying to do. Why were they doing that? Was it out of concern for the interests of the individual class members? If you have a B2 class, you are not required by the rule to provide notice. You are not permitted to opt out. So the attorneys who fight for B2 certification are basically fighting to prevent their own clients from receiving notice of the litigation. They are fighting to force those clients to stay in the litigation, even if, as a result of their own free will, they would want to get out. This is not the traditional attorney-client relationship. Fourth, simple fact, the attorneys have considerably more money at stake than any individual class member. That's not true in the one-on-one attorney-client relationship. Even the contingent fee relationship, the client always has a greater financial interest than the attorney does. So look what we've created with the modern class action. We have a situation where we have those making the decisions having no one-on-one relationship with the clients, having built-in potential for conflict of interest between them and the clients, and having considerably more money at stake than any individual client has. It sounds considerably more like the third-party funders than it does the traditional class situation. Finally, I refer to the non-existent class, what in my book I refer to as the faux class. I thought of, as an analogy, going to Washington and seeing on the street a cardboard cutout of Barack Obama, and a photographer will take your photograph with your arm around this smiling cutout of Barack Obama, and you get a picture that you take home that looks like you were standing next to Barack Obama. But you weren't. You were standing next to a cardboard cutout of Barack Obama. Many classes today are very similar to that, particularly in what John Coffey called the type B class action, the negative value class actions. We have classes that are basically comatose. If they've gotten notice, they don't know quite what it means. My father-in-law once called me up, totally panicked, wondering whether he was getting sued, and I explained to him no, that he was an absent class member, and it's the only time he thought I was worth anything. They don't ever ultimately recover anything. Most of this money goes off to CPRE awards. And so the class is there as this cardboard cutout to make it seem like there is somebody there who is a real party in interest other than the attorneys. And they're really not. And this led me to an insight, which is that the class action is not simply individualized litigation writ large. Its DNA is different from the traditional litigation model. This doesn't mean it's inherently invalid, but it does mean that we have created a hybrid, something between third-party funders who have no real allegiance to the client and the traditional attorney-client relationship. In many ways, this is presents much greater concern than does the third-party funding, because in a third-party funding of an individualized litigation, the attorney who does have the face-to-face relationship with the client can act as a filter. There's no filter here. And when the 1966 Rules Advisory Committee created a class action to, for the first time ever, join together claimants who had no substantive pre-litigation relationship, they basically created this new procedural animal. And that should cause us to recognize there's a need to have concerns that we don't have in the traditional one-on-one relationship. Well, the goal should be to obtain the benefits of this oxymoronic capitalistic socialism, because in this case, unlike the third-party funders, it's the plaintiff's attorneys who are rolling the dice, often funded by loans rather than investors. But they're rolling the dice and often will do good in valid litigations that couldn't have been brought otherwise. But there are pathologies that grow out of this that do not grow out of the traditional one-on-one litigation model, and we need to avoid that. First is to recognize that under Article 3 of the Constitution, while the attorneys in practice can be the real party in interest, as a technical legal matter, they can't be. That's why we need actual individuals for whom they are working, who will actually be benefited. And that's why I have recommended that Rule 23A be modified to include another prerequisite, a finding by the court that if the plaintiff class prevails, there will be meaningful relief to a majority of the class members. Something that's not considered now, even though in many of these cases, everybody knows right from the get-go, the claimants are going to receive nothing at all, and nobody seems to mind that. Avoiding the conflict of interest between the attorney and client. I believe all mandatory classes are unconstitutional. There is an individualized due process right to seek out governmental help, in this case the courts, to protect your property interest. And every plaintiff has a chosen action that is a protected property interest. The Supreme Court, starting in Hansberry versus Lee, has said, oh yes, due process applies to class actions. But they've done it in a paternalistic way. They've done it to make sure those representing your interests are doing a good job. I'm talking about a different kind of due process concern. I'm talking about an autonomy and an interest to make the decision for yourself. And that might well require an opt-in requirement. Because to waive your constitutional right to protect your own interests through pure passive behavior creates significant problems. I recognize the dangerous impact on the class from requiring opt-in, and on balance, maybe we would have to avoid that. But it's something to think about. CPRE, I know people who call it Cypre, and I have great respect for them, but that's not really the way it's pronounced. And if my students mispronounce it on the final, I take off. But this idea of the second best in the litigation process, there is no second best. Either you're compensating those who were injured or you're not. To give money to Mother Teresa is a very nice thing to do, but Mother Teresa wasn't injured. Mother Teresa has no stake in the litigation, and basically it transforms the DNA of the underlying substantive law into the equivalent of a civil fine. Finally, I mentioned the revision of Rule 23A. So what I've done is look into third-party financing, find that with some questions legitimate, but see a whole new way to understand the modern class action by analogizing it to third-party funding. Thank you very much.
Can you stand up or do it here? 20 minutes.
So good afternoon, I guess it is now. I want to thank the organizers for an extremely interesting conference and for inviting me to talk. I'm going to talk a little bit about what third-party funding is, what are its promises, and what are its pitfalls. And then I'm going to give a few examples of how we can solve or minimize some of the problems that are inherent in litigation finance through contracts. Contracts are not the panacea, but they can go a long way. So that's the purpose of the talk and basically where I want to go. I thought I'd start by just defining what third-party funding is. What we're talking about is third-party investment firms, or I'm at least focusing on firms like Burford, the firm that invested in the post-judgment proceedings in the Chevron Ecuador dispute, that are set up and they specialize in funding litigations. In my work, I focus mostly on the funding of commercial claims, not tort claims, but there's a lot of overlap. The industry is very secretive. Contracts are not publicly available. The funders regard them as trade secrets. Even when I asked to see them under non-disclosure agreements, and there was just absolutely no way. But a few of them have made it into the public domain in their entirety, or provisions of them have made it into the public domain in satellite litigation, usually when the plaintiffs turn around in what I call buyer's remorse litigation after they win judgments and challenge the agreements. And one agreement that made it into light under different circumstances is the investment in the Ecuadorian post-judgment litigation. And for me, that contract really, and the funding of this litigation, really highlights both the promises and the pitfalls. So I started out, I'm working on a series of papers, started out by analyzing that contract, and then it occurred to me that it might be very beneficial to try and develop a model contract in order to help parties, clients, potential clients, and their lawyers to draft better contracts and try to solve some of the problems. In doing that, I've developed an analytical framework that I don't have time to talk about, but I invite questions about it in the Q&A. I'll just stipulate it for now. That analytic framework is that litigation finance is incredibly similar from an economic perspective to venture capital. And what follows is that we have 60 years of experience with venture capital contracting. There's sample contracts and a lot of literature analyzing what are optimal and just contractual arrangements. And that's what led to this project. In this project, I am developing a model litigation finance contract. I'm trying to contract behind the veil of ignorance, to use a Rawlsian phrase. I'm trying to think about a deal that would be profitable for funders so that they actually engage in it, but that would be fair towards plaintiffs and that would minimize the problems of conflicts of interest between the three parties involved, lawyers, funders, and attorneys. And I invite the public to contribute and critique. This is a draft model contract, and I invite all of you to critique, tell me I'm getting things completely wrong and how it can be done better. So with that in mind, I want to go ahead and talk a little bit about what are the promises and what are the pitfalls and some solutions. So in terms of promises, I'm going to talk about promises for plaintiffs and for the public. You'll notice I'm not going to talk about the promises for the investment firms, which are obvious and, to me, not a normative concern. First is the obvious benefit. I'll start with plaintiffs, and the obvious benefit is access to justice, and when we're talking about transnational litigation, access to transnational justice, which can be much more expensive and complex. More interesting, and borrowing on the venture capital literature, financiers of either ventures or litigation provide non-cash contributions. And those are understood in the venture capital, and I argue in this context as well, as even more important than the capital that they provide. So I'll give you some examples. Financiers bring expertise. They monitor, so in this case, they can monitor the lawyers monitor them. There's what economists call agents watching agents effect. Third-party funders bring reputations, and through them a signaling device, so they're signaling to defendants. We've looked at this through due diligence. We think that it's profitable enough that a third is going to compensate us for all of our investment, which can promote early settlements and better settlements, higher settlements for the plaintiffs. Those are some of the benefits for the plaintiffs. For the public at large, I think it stands to promote rule of law, and transnationally in particular, to promote corporate accountability. This is a very American style. I'll stipulate, even though you may detect an accent, I'm not American, but nonetheless, I've been here long enough that I have an American bias in favor of private enforcement of the law. This is especially important in transnational litigation, where any debate between should we regulate privately through private enforcement of the law or through a government is moot. There is no government, and if there's not going to be private enforcement of the law, I think there's going to be and there is today, a serious rule of law gap. And another interest to the public is the development of jurisprudence. The ability to fund litigations means the ability to invest in precedent, to develop precedent, and cases that can't be funded to go through to trial obviously don't generate any benefits in terms of development of the law. I want to talk a little bit about pitfalls. The key pitfall from a plaintiff's perspective is that there's a very unequal bargaining power in negotiating the funding agreement. Again, the contracts I look at, the deals I think about funding, are funding of corporate claims by very sophisticated parties, by very large corporations, or very sophisticated individuals. Even these plaintiffs are not in an equal bargaining field in terms of negotiating these agreements. I've talked to many of their lawyers, and they agree part of it is because of the complete lack of transparency. The transaction costs of trying to figure out what are all of the issues are tremendous, and you end up with a document that funders developed, and you maybe try to tweak it in the margins. But to kind of quote one lawyer, he said, "I'm a litigator. I'm not a finance attorney. This is a finance deal. I don't know how to draft finance deals, and I can't justify bringing one of my finance partners to do so because this is not billable." So very unequal bargaining power, which leads to things like suboptimal pricing for the plaintiffs, overselling interest in the litigation. In addition to that, of course, conflicts of interest. Professor Redish alluded to that, and we're all lawyers in the room. We all have intuitions that we bring from the contingency fee context. Finally, problems of commodification of legal claims. By that I mean the incentive of funders to monetize and to, as we've seen in the deal in this litigation, penalize plaintiffs if they seek things like injunctions and environmental relief rather than damages. There are also pitfalls for funders, which I'm interested in just because contracts should be as efficient as possible for the deals to go forward, since my normative take is that overall funding is a positive phenomena if done right. And here there's predominantly three kinds of problems: extreme agency costs, so extreme conflicts of interest; extreme information asymmetry to the, that runs especially against the funders; and extreme uncertainty and high risk in the asset. And finally, there's the business risk of buyer remorse litigation, which is expensive. So I want to give you a few examples of contract solutions that I suggest. One is I suggest, and I offer model language for all of the conceptual suggestions. And I should say I'm drafting the contract with a co-author, Abigail Field, who's a transactional lawyer. I'm a litigator. One solution is minimum plaintiff recovery. Seems simple, but these don't appear to be in the contract. So some kind of a provision that says here's a minimum, and I suggest that parties take their cue from unconscionability analyses in the contingency fee case. So the kind of formula that exists in the Burford investment in the Ecuador case, where under certain circumstances funders receive 80% of the proceeds, can be easily avoided. The next and highly controversial, but maybe can address some of Professor Redish's concern, a fiduciary duty to at least bring funders to the same kind of situation like attorneys. We know that's an imperfect solution, but we should at least have fiduciary duties, or parties should consider bargaining for them, among other things, because unlike attorneys, funders do have fiduciary duties, but they have that to their investors. So right now, they're actually obligated to maximize profit for their investors at the expense of the clients. So I recommend at least equalizing that set of duties by imposing a contractual fiduciary duty. I also recommend all kinds of duties that run the other way, so duties on the plaintiffs, like duties of cooperation, which I take from the insurance contracts, duties to inform, to reduce the information asymmetries. I suggest a host of representations and warranties that can reduce conflicts as well as information asymmetries. For example, representation that the funder has minimal capitalization, and a warranty that they will continue to have minimal capitalization the way that insurers have to do by operation of law. Representations and warranties against no conflict. Right now, there's nothing stopping third-party funders, unlike attorneys, to deal with both sides. They can invest in both sides of the litigation and hedge. They can take the plaintiff's information, which they glean, and sell it to a third party. We can deal with that through contracts. Full disclosure on issues such as how they're capitalized and how they're organized. So if funders, for example, have a need based on their partnership agreements, they're set up like private equity funds. If they have a need to liquidize within a certain term, which is going to create a problem in terms of actually funding, they need to disclose it, or they need to not be in that situation. Another kind of contractual solution I'm suggesting is independent counsel. This is the idea that plaintiff is well advised, that their lawyers are well advised to suggest to their own clients, please take an independent counsel for two purposes. One is to give you advice on the funding agreement, because we have a conflict of interest. Our payment is actually coming from this third party. And B, to help clients assess settlement decisions, which is where the conflicts come to their starkest relief. Finally, I'm not going to go into great details, but I recommend, if anybody's interested in the Q&A, to go into this. The heart of the balancing act in venture capital is staged funding. And one of the highlights, I think, of the model contract that we're offering is that we have modified stage funding to litigation, taking into considerations the difference between litigation as an asset versus a startup company as an asset. So just to give you a little bit of a sense, stage funding is a form of funding that is incremental and tied to milestones. So in the venture capital example, once you develop an operating prototype, that's a milestone, we'll release more funds. Once you have a certain number of contracts, sales contracts in line, that's a milestone, we'll release more funds. We're adapting it to litigation. Milestones are things like the completion of discovery, the survival or not of a dispositive motion, and so forth. And stage funding reduces, again, no panacea here, but it reduces the risk and uncertainty, it reduces conflict of interest, and it reduces information asymmetry. It connects release of funding to the development of the case in a positive way, cooperation by the plaintiff, and it also allows plaintiffs to reprice and rebargain, so if they oversold early on, they can reprice later on, and vice versa. The same is true for funders as well. So that, in a nutshell, is what I think about litigation funding.
Thank you. The ideas that are on the table now are, I think, extraordinarily interesting, ranging from a kind of theoretical overview of the entire class action system to a kind of really nuts and bolts of how one makes it work. And I just have a couple of quick observations, and then I really want to throw it open to you for questions. The first is I couldn't agree with Marty more about the governance issues of class actions. I mean, once you have a lawyer who's running the show, and the lawyer has an important financial interest in how the case comes out, and that financial interest may deviate from the best interests of the class, you have a very serious agency problem. It's nothing new. We've recognized this now for the last 15 or 20 years and tried to work through solutions to the agency problems that inevitably emerge when either an outside funder or a lawyer has a significant role in funding the litigation. And it seems to me that the challenge is, and this borrows from thinking that John Coffey has done over the years, the challenge is to conceptualize the class not as a group of litigants, but to conceptualize the class as an ad hoc political entity that is seeking to advance a common interest, just like any other political interest group seeks to advance a common interest, and to work out mechanisms of governance within the structure of that class that are intuitively fair to us, mechanisms of notice, mechanisms of control, and that's a challenge that people who are in the class action world have to meet in order to make those entities morally defensible when they bind their participants. So I agree with him there. Where I disagree with him is that he seems to view these entities as solely mechanisms for compensation. And viewed as solely as mechanisms for compensation, the class action has lots of holes in it, not the least of which are the silly negative CPRE things where nobody's being compensated except the lawyers. But the class action, the modern class action, is not just a compensation mechanism. It's a crucial law enforcement mechanism. As Maya points out, the tradition in the United States is to delegate very important aspects of class action to private entrepreneurial actors, unlike in many of the other governmental systems where they build large government bureaucracies to do it. We think we can do it better through a market mechanism where we delegate to individuals. And I think it's fair to say the modern class action lawyer in the United States today is the 20th and 21st century analog of the 19th century privateer. We issued letters of marque to privateers because we didn't want to pay for a navy. And the letters of marques, the privateers sailed up and down the coast, and they captured vessels, and they got paid from prize courts, which compensated them for performing the task. In fact, that was the first elite legal profession in the United States, was as a prize lawyer. I think when you certify a class now, you issue a letter of marque to a private privateer who sails up and down the coast and captures corporations for fun and profit. And the question is, how should we govern that mechanism? Now, to say that we won't have that mechanism leaves us with two alternatives: either the building of huge government bureaucracies to do it inefficiently, or a state of lawlessness where the law simply doesn't get enforced on behalf of large numbers of private individuals who lack the resources to do it on their own. So it seems to me we don't have a choice. We have to go down this road. Question is, how do we get it right? And that's where Maya's solutions are so helpful. And let me just say two last quick things. One, on the impact of third-party funding. The impact of third-party funding is different than simply having lawyers borrow money from the bank. When lawyers borrow money from the bank and fund it that way, they stay up at night and they worry and they sweat, and there's all sorts of possibilities for agency costs. But they don't have to suck up to the bank about how they're dealing with the litigation, and they don't have to have conversations with the bank about what to do. Now, I've lived most of my life as a litigator, as many of you know. I've brought hundreds of class actions. I've lived my life as a litigator on the kindness of strangers. I've never been able to fund litigation myself. I've always had to go out and get money for it. And I usually get money from the foundation world, and sometimes I get money from rich donors who do it. And don't you think for a minute that I'm not in their pocket when I litigate. I worry about pleasing them. I worry about doing something that will enable me to get continued streams of funding from them in the future, and it affects my judgment. And if it affects my judgment in a kind of foundation B2 world, where money is not really playing, financial gains are not really playing a significant role, in the B3 world it's going to be worse. Suppose you're a repeat player with an equity fund, and you want to be sure that they not only fund you today, but fund you tomorrow. Who runs that loss? And that's a real danger that we have to deal with. Then finally, let me actually suggest something of my own that I mentioned to Deborah last night at dinner. My wife is a foundation executive. I've finally ultimately married a foundation executive. I spent so much time courting them. So my wife is a foundation executive, and she was very active in the. Was the women's rights officer at Ford. She's now their director for low-income employment. But during the 90s and 80s and 90s, when the micro-lending for women, especially in India, began, she was quite active in that. And she once asked me, why don't you have a fund like that for class actions? Why isn't there a pool of revolving money that is created either by a consortium of foundations or the government or something like that, with a board of directors that will carefully worry about the social, it's a social investment, whether the social return on the money is equivalent, is adequate, not necessarily the financial return, and then you're required to put money back into the revolving fund. In other words, if you, the same way that the women in India paid back those microloans religiously. And you keep the revolving fund going, and that's a source of funding that may be a little better than all of this. So these are just suggestions that jump out.
Can I take a minute to respond to what you just said?
Sure. And then...
Yeah, just a minute. Rule 23 is not a roaming device to do justice. It is a federal rule of civil procedure. It comes right after Rule 22, interpleader, and right before Rule 24, intervention. A lawsuit does not arise under Rule 23. It arises under the substantive law that's being enforced, and invariably that substantive law has as its remedial measure compensation to injured victims. What you've just described, your letters of marque analogy, and it's certainly descriptively accurate as to what's going on, but legally you've transformed the underlying substantive law into a qui tam proceeding. That is not what the legislature did. That's not what the legislators who voted for it stuck their neck out for politically to be judged at the next election. Basically, through the disguise of Rule 23, again, a federal rule of civil procedure not allowed to abridge, enlarge, or modify substantive rights, you've completely altered the remedial mechanism of the substantive law. If Congress wants to do that, or a state legislature wants to create qui tam, knock yourself out. We can talk about that, but then it'll be up to the political judgment of the electorate as to whether they like that or not. Here, we basically have political fraud going on. We basically have, under the guise of a procedural device, a complete change in the underlying substantive law. Federal Rule of Civil Procedure is too small a tail to wag that dog.
I agree. It was a great change in the substantive law. My goodness, it allowed poor people to get enforcement. What a shocking change.
Rick Marcus, I admit to fraud, I guess. That's not what I got up to say. I had a different question. That was tongue-in-cheek.
We can edit
I had a hand in drafting the 2003 amendments to Rule 23, which included Rule 23G on class counsel. I want to ask about something that picks up, I believe, on a comment made several times by Mr. Boutros, which is hedge funds were paying for this litigation. Isn't that terrible? And I remember Tom Wolfe's Bonfire of the Vanities and the image there of the Wizards of Wall Street, and it certainly sounds unnerving. I'm interested in reaction, partly based on Bert Newborn's comments. I'm interested in a different reaction that I had as you folks were presenting, and that is, maybe if this is like venture capital and startup funding, we ought to applaud or at least feel comfortable, maybe confident, with these folks who are going to pick and choose based on careful research and provide their funding only for cases that hold promise, and then maybe that's bad only if you think promise in court is somehow inappropriate or wrong, and we ought to have some other measure of things. I assume promise in court is what we ought to regard as the right measure, and if so, maybe this kind of funding is a good thing. Herbert Kreitzer said contingency fee lawyers are careful about which cases they take. Aren't venture funders also?
Yeah, I actually agree. I think that if you're looking to profit and you need the business model of most of these firms is they need 3 to 4 times return on a case, and they only get a third of the recovery. I don't see a systemic situation where they're investing in non-meritorious claims. These are not going to yield the kind of awards that they require. I'm not talking in the margin about abuse, but systemically the incentives are such that it just doesn't make sense from a business perspective to invest in anything in cases that are not meritorious. I have a big caveat for that, and that is as long as brace yourselves, as long as lawsuits are not securitized and that we don't develop securities that are backed by litigation claims, which is not a fantastical idea. I mean, I'm sure it sounds fantastical, but I know that some people are thinking about that. That creates a moral hazard, and that can create a real problem. But barring that, I just don't see the economics of investing in non-meritorious litigation. And I also want to say more generally, I also started looking into this area with the same kind of intuition that I think a lot of people have, which is profiting off of other people's injuries. But at the end of the day, I concluded that it's an aspect of finance. Finance generally is a form of a utility. We need finance for our homes and our cars and our education, and there's really no reason not to provide financing for people to have their day in court. And I believe that we should regulate the financing industry generally, and this is no exception, so that there aren't abuses. But it's a form of financing, and we kind of know how to deal with funding if we have the political will to do so.
Could I add one thing to that? I'm probably not one to talk since I invested in Betamax. Tried to get on the ground floor there. I'm not sure it would necessarily work the way you're describing, Rick, because it would depend on how big their portfolio is. I mean, if they feel they can protect themselves by investing in so many litigations that they'll lose some, but they're, when the dust settles, they're likely to win more, then you wouldn't have that benefit. But at the very least, I don't think you'd have them purposely investing in frivolous litigation. So at the very least, you wouldn't have a perverse incentive. You might have the benefit you're talking about, you might not, but the worst it gets you to is back to ground zero.
We actually have some data on this issue. So the first third-party funding class action litigation is a publicly traded company in Australia called IMF that now has a subsidiary in the US. IMF puts all their data on the outcomes of their cases on their website, so you can go and read them. Their cases have an extremely high percentage of wins, and that is not because of what has been popularly called blackmail settlements in the US, because many of the Australian class actions actually are tried and fiercely contested. So the question that many people have about the Australian situation is actually, since publicly financed funding has kind of taken over the class litigation scheme in Australia, has it actually now produced more risk aversion than one would want if one looks at a system in terms of access to justice. It's clear from the Australia case that what has happened is is the class action scene there has been transformed into a scene for financial litigation, mostly on behalf of institutional investors. That was a comment. I actually have a question for Maya. So Maya, I found your comments very interesting, and particularly your laying out of provisions for what would be an optimal contract. And since the contract in the Chevron case was made public due to the litigation, and since we are here in part thinking about lessons from Chevron, could you make some comments as to that contract and how well it does or doesn't match what you think would be the provisions of an optimal contract?
Thank you. Yes. First of all, I published a paper on this, so if anybody wants to see my views at length, it's in the recent issue of the William and Mary Law Review. I think that the contract is problematic from both a justice perspective and an efficiency perspective. I'll start with the efficiency perspective. In terms of the stage funding, which as I said, it's the heart of these kinds of finance arrangements. It's a very rudimentary, peculiar form of stage funding. And I won't belabor that point. I'm happy to follow up if anybody's interested. More importantly, in terms of justice, we see the things that that a lot of commentators have been concerned about. For example, funders controlling who the lawyers are, funders controlling or heavily influencing the litigation through the mechanisms of control of the purse string, funders getting, under certain circumstances, very high percentages of the award, leaving very little for the plaintiffs. Commodification, so there's provisions there that that have the effect that if the plaintiff accepts environmental remedies, they actually have to pay the funder the value of their prorated. So I think it's not good. I do want to say that I'm a proponent of the promises that funding transnational litigation has. Part of my interest began, I've done a lot of work in Africa, including with governments in Africa, and I've seen cases where, frankly, I mean, if you just got a lawyer to write some nasty letters to enforce contracts, so that governments would get the royalties and other things they deserve contractually from multinational corporations, we can see a difference in the continent. But you do need a bridge there, both in terms of funders to capitalize, but also the non-monetary contribution that I talk about. So I'll stop there.
Ted?
Thank you. Since Professor Marcus mentioned my comments, I wanted to just comment on the notion that just because you have third-party financing shows there's merit. I mean, in the Chevron case, as you probably know, Burford in September of 2011 sent a letter saying to the plaintiff's lawyers, we believe that you, in particular your U.S. representatives, engaged in a multi-month scheme to deceive and defraud in order to secure desperately needed funding. And then they go on to say they concealed facts from Burford. So I think I'd be interested in the panelists' view. Is this going to open up a whole other front of disputes and litigation? And so funding is going to lead to fraud suits about the diligence that went into the case. And it's a very strong letter. So I beg to differ that we can depend on the efficiency and the judgments of the investors. And I think this case shows that that's not true. And Burford probably would disagree with that comment. I'd be interested. Do you think it's going to cause more litigation?
The only thing I'd say is, at my age, I thought I had seen about as dirty as a litigation could get, but I was wrong. I mean, just every aspect of this case is beyond what I've ever seen before. If fraud happened, then you might have more fraud lawsuits. There's no inherent reason why it would lead to that. I suppose it creates a whole new level of potential litigation, but that's true of any kind of new financial arrangement. I don't see why that would.
You realize that what this does is it creates an entire new line of employment for legal academics. I field 5 calls a week in my office in New York City from potential equity investors in some form of litigation, asking if I would give an opinion on the appropriateness of going forward. And since I am so little, I don't understand finance, and I don't understand the venture capital world, so I'm nervous about getting involved in a process that I don't know whether it will be good or bad for the system, so I stay back. But having been here for the day, I think what I'm going to start doing is saying, sure, for how many points can I get? But your point is well taken. Someone has to be the filter to be able to allow the investor to make sure they're getting all the information they need in order to make a reasoned decision about whether to invest. And
your experience, doesn't your experience show that they are at least making that,
well,
that effort?
Yeah, they're calling around. I mean, they are trying to use academics. Now, that's the other problem is, what do academics know? And so,
don't tell them that.
Okay, this has been a terrific morning. Not the least that we're ending on time. And so I thank you all, and I thank the speakers very much.